If you're an architect in Queensland providing contract administration, here's something worth understanding before a defect dispute lands on your desk. Let's walk through the key takeaways. First, and this surprises a lot of practitioners, architects providing contract administration can be legally taken to carry out building work under Section 71, Statutory 2B of the Queensland Building and Construction Commission Act 1991. What that means in practice is that you can have direct exposure to statutory rectification directions, not just the builder. Second, the time frame is longer than most people expect. The Queensland Building and Construction Commission possesses the statutory power to issue a direction to rectify up to 6 years and 6 months after the work is completed, under Section 72A(4) of the QBCC Act. Now, this period extends well beyond the QBCC's own internal policy thresholds. That's 12 months for non-structural defects and 6 years and 3 months for structural defects, which govern when the Commission will ordinarily consider issuing a direction. But here's the key distinction: those policy thresholds are not statutory outer limits. The 6-year, 6-month cap under Section 72A(4) applies to all building work, regardless of how the defect is classified. Third, let's talk about defending yourself. Defending against a proposed direction using the Section 72(5) unfairness exception typically requires contemporaneous written evidence. For example, evidence of the client ignoring design advice or substituting materials, and that leads to the final and arguably most practical takeaway. Treat verbal warnings as weak evidence. While oral evidence is admissible, in practice only contemporaneous written records that name the non-compliant work and direct its rectification will reliably support a Section 72(5) unfairness defence before the Commission or before the Queensland Civil and Administrative Tribunal. So the takeaway is simple. Write it down at the time, clearly. That paper trail is your protection.